Malcolm Reed arrived at the Jacksonville County Courthouse at 7:43 in the morning. He was not early because he was anxious. He was early because he was careful. 15 years of standing in courtrooms had taught him that the hour before a major trial reveals things the trial itself never will. Who clusters near which doors? Who whispers and who performs? Whose confidence is real and whose is borrowed? So he came before his team, before the defense had assembled, before the room arranged itself into its official shape. He was 42 years old, lean, still in the way that comes from years of running and not sleeping enough and carrying things internally that other people would have put down a long time ago. He wore a navy jacket dried imperfectly after he had been caught in the rain walking from his car. His shoes were dark at the toes from the puddles on Congress Street. He carried a slim folder under his left arm and a worn trial notebook under his right. The notebook's spine had been repaired twice with black electrical tape. No entourage, no briefcase, no associate trailing behind him with documents. Just Malcolm, just the notebook, just the work. He was the special prosecutor appointed by the Florida Attorney General's office to lead the most consequential public corruption trial Jacksonville County had seen in 20 years. 14 defendants had been indicted. The case had taken 6 weeks of preparation, 2 investigators, and more late nights than he cared to count. What almost nobody in the courthouse knew that morning was something small and quiet and completely decisive. Malcolm's phone had been running a passive audio capture application since the moment he stepped through the metal detector at the entrance. It was not surveillance. It was protection. He had built the habit 4 years earlier after representing a young black man named Terrence, who had been charged with resisting arrest. Terrence had described in precise and unflinching detail exactly what the arresting officer had said during the stop. The official police report contained none of those words. The case was dismissed anyway, but Malcolm had walked out of that courtroom carrying a specific quiet fury at how easily the truth could be erased when no one outside the moment was listening. The app uploaded to a secure cloud server every 3 minutes. It had been running since 7:38 a.m. He was not thinking about it. He was thinking about the cross-examination he had planned for the third witness. There was a question he had written 3 different ways the night before and still wasn't satisfied with. He was turning the phrasing over in his mind, testing each version, when the first problem of the morning stepped into his path. Wayne Pritchard had been working courthouse security for 11 years, 4 months, and somewhere around 12 days. He was 49 years old, white, broad in the shoulders, with a square jaw and small, fast-moving eyes that his wife had once described as always checking something. He had tried to become a police officer twice, failed the physical exam at 26, tried again at 28 and failed by a smaller margin, which somehow made it worse. The courthouse security position had opened up shortly after. He took it with an understanding that was never stated but always present. It was the closest approximation of what he had actually wanted. Authority, in whatever form it arrived, was something Wayne Pritchard wore carefully and completely. In 11 years, he had developed what he privately thought of as a facility for reading people. He believed he could assess within 10 seconds of visual contact who belonged in a courthouse and who did not. He had never articulated the exact criteria, not even to himself. Articulating them would have required naming things he preferred to leave unnamed. But the assessment was always instant, always confident, and for 11 years it had never been seriously challenged. He had received 11 documented complaints during his time at the courthouse. Deputies got complaints. That was the job. His supervisor had told him so after the third one, and Pritchard had carried the reassurance forward like a credential of his own. 8 of those 11 complaints had come from Black or Latino attorneys, witnesses, or court-appointed advocates. 2 had come from Black attorneys there to represent clients in active cases. Both had eventually been allowed through, but only after delays of 9 and 14 minutes. Both had filed complaints. Both complaints had been closed without finding. Pritchard had never seen the data. No one had assembled it and shown it to him. No one had shown it to anyone. He had also never been formally disciplined. In his mind, this confirmed everything. On the morning of October 14th, Pritchard was posted near the perimeter of the Courtroom 4A Special Access Corridor when he saw Malcolm Reed walking toward him. He took one visual sweep. Navy jacket, imperfectly dried, dark shoes wet at the toes, slim folder, worn notebook with electrical tape on the spine, no tie, no briefcase, no associate, no expensive watch. 3 seconds, maybe less. The assessment was complete before Malcolm reached the line. Pritchard positioned himself slightly in front of the access point and waited. Malcolm was still working through the cross-examination question when he became aware of the deputy's posture. He recognized it immediately. He had seen it hundreds of times in different contexts. The slight forward lean, the feet planted, the eyes doing their assessment work without any attempt to conceal it. He did not slow down. He did not speed up. He stopped at a natural conversational distance. The deputy did not say good morning. He said, "This corridor is under special access restrictions. You need to be heading to the public waiting area." Malcolm said calmly and clearly that he was lead counsel for the state and needed to enter Courtroom 4A. The deputy looked at him with the expression of a man who has already decided the answer to a question and is only waiting for the conversation to confirm it. He asked which defendant Malcolm was related to. Those words. Malcolm absorbed them the way he had learned to absorb that kind of thing. Not by not feeling it, but by feeling it fully and precisely and then setting it aside the way you set something hot down carefully before you pick up what you actually need. He told the deputy he was not related to any defendant. He was the special prosecutor appointed by the state attorney general's office. The deputy's expression did not change. He asked for credentials. Malcolm produced his bar card and his state appointment letter. The bar card was in a temporary plastic sleeve because his wallet had been damaged in a rainstorm 2 weeks earlier. The letter bore the seal of the Florida Attorney General's office, the case number, and Malcolm's name in the heading. Pritchard looked at the bar card. He looked at the letter. He read the heading and stopped. He did not read further. He said he had seen fake paperwork before. He said he would not delay court proceedings for nonsense. Malcolm kept his voice measured. He told the deputy there were 3 ways to verify his identity. Check the court docket, which would list his name as lead prosecutor. Call the clerk's office at extension 114 and ask for Sandra Okafor. Or contact Judge Carter's chambers directly. He said he would wait as long as any of those 3 checks required. He said he understood the deputy had a job to do. The deputy said he would not hold up a courtroom on the basis of a piece of paper in a plastic sleeve. In the corridor to Malcolm's left, reporters had begun to drift closer, the way crowds move toward tension without quite deciding to. 2 phones were already raised. Recording or not recording, it was impossible to tell from where Malcolm stood. He was aware of them. He kept his eyes on the deputy. He kept his voice low. He had one objective, and it was not creating a spectacle. It was getting through that door and doing his job. That restraint, that absolute disciplined restraint. It read to Wayne Pritchard as the behavior of a man who knew he did not belong there and was trying to bluff his way through. He told Malcolm to stop trying to sound educated. The words came out in the flat tone of a man who considered them simply accurate. A young assistant prosecutor named Asha Mendez recognized Malcolm's name from across the corridor and started toward them. Before she could speak, defense counsel Clifton Vance stepped out of a nearby doorway. He was in a $6,000 suit. He observed the scene with the practiced calm of someone who has made a career of turning other people's problems into his own opportunities. He asked with pleasant curiosity whether security was removing someone. Pritchard heard the defense attorney's tone and took it as confirmation. He reached out and gripped Malcolm's arm. Malcolm told him precisely and quietly not to touch counsel. Pritchard said counsel does not show up looking like he came from a bus station. Those words. That specific combination, delivered with the flat certainty of a man who believes he is simply describing a fact. Malcolm felt something shift in his chest, not collapse, not break, but change temperature. He thought of every client he had ever represented who had been talked down to in a hallway exactly like this one. He thought of Terrence and his disappeared words. He thought of the phone in his jacket pocket and realized with a terrible clarity that it was still running. Pritchard walked him to the public waiting area. He told a second deputy not to allow Malcolm back through without real credentials. He made air quotes with his fingers when he said the words. Malcolm stood in the public waiting area of the Jacksonville County Courthouse and called Marcus Webb, the Attorney General's representative, who was 9 minutes away in traffic. He gave Webb the deputy's name, the badge number he had read from the left breast of the uniform, and a factual summary of what had occurred. 3 sentences. No editorializing. He hung up. He looked at the heavy wooden doors of Courtroom 4A from across the lobby. Behind those doors, the most important trial of his career was scheduled to begin in 16 minutes. And he was standing in the waiting area with the people who had come to watch. The phone in his jacket pocket was still recording. The thing about being publicly humiliated in a space you are entitled to occupy is the way it generates its own specific silence. Not the silence of an empty room. The silence of people who have seen something wrong happen and are calculating what it costs to intervene versus what it costs to stay quiet. 2 reporters had seen the removal clearly. Dana Reyes from the Florida Times-Union had been in the building since 7 a.m. She was composing a text to her editor that read, "Something just happened. Stay close." A freelance videographer named Craig had been filming general courthouse footage all morning. He did not know yet what he had, but he knew he had something. Inside Courtroom 4. The defense team for 11 defendants was arranging itself with the choreographed calm of people who are very good at appearing calm. Clifton Vance had returned from the corridor and said something quiet to his co-counsel that produced a short, barely audible laugh. In the gallery, a county employee named Darnell Hayes sat in the 3rd row on the left. He was 53 years old. He had worked for the county public works department for 19 years. He had watched his supervisor approve payments for contracts he knew from his own direct experience were falsified. He had kept records. He had been told 3 times by 3 different people in official positions that there was nothing to be done. He had finally reached out to Malcolm's investigative team 8 months earlier through a public integrity hotline. He was more afraid than he had ever admitted to anyone, including his wife. He had thought about not showing up. Multiple times. He had made himself come anyway each time because the alternative was going home and living with what he knew. He watched the exchange in the corridor from the gallery doorway because the doors were still open. He watched the deputy grip the prosecutor's arm. He watched Malcolm walk toward the waiting area. He felt something cold move through him, if they could do that to the prosecutor. Here, on the first morning of the trial, he went back to his seat. He sat very still. At 9 a.m., Judge Evelyn Carter entered Courtroom 4A. Judge Carter was 61 years old and had been on the bench for 16 years. She was known in the Jacksonville legal community for 3 things: an absolute intolerance for wasted time, a photographic familiarity with the federal rules of evidence, and the ability to identify nonsense from approximately 40 feet away. She took the bench and looked at the prosecution table. It was empty. The courtroom absorbed this fact in stages, first a murmur, then a charged stillness. The clerk tried to reach the prosecution team by phone. The call rang. No answer. Clifton Vance rose to suggest that the state's apparent absence raised concerns about the prosecution's preparedness for a trial of this complexity. Judge Carter looked at him with an expression that stopped him mid-sentence. She told the clerk to try again. Wayne Pritchard heard Malcolm Reed's name for the first time spoken aloud by Judge Carter herself, and the experience was not like hearing a name. It was like hearing a sentence pronounced. He was posted near the courtroom wall, watching the gallery the way he always did when Judge Carter's voice carried clearly across the room. "Where is Mr. Reed?" The name connected with the morning's events with a force that was entirely physical. His right hand, resting flat against the wall beside him, slid downward 6 inches before he caught himself. He looked immediately at the floor. Dana Reyes in the press row was looking directly at him at that moment. She wrote something in her notebook. Pritchard's mouth had gone dry in the particular way that happens when the body processes information the mind is not ready to accept. He reconstructed the morning rapidly and involuntarily, the way you replay a car accident. The navy jacket, the wet shoes, the slim folder, the appointment letter with the seal he had not read past the heading, the way the man had listed 3 verification methods with the ease of someone who had done this before, not because he was bluffing, because he knew exactly what was true and was giving Pritchard every possible chance to find it out. The deputy beside him, a younger man named Castillo, noticed his expression and looked away. Outside, Marcus Webb's car had just pulled into the parking structure. Malcolm was waiting at the building entrance. He was still entirely composed, which was more unsettling than anger would have been. He was not thinking about Pritchard anymore. He was thinking about Darnell Hayes, sitting in that gallery and what it must look like from the 3rd row on the left to see the prosecution table standing empty. He straightened his jacket. It was still damp at the collar. He didn't care. Marcus Webb appeared through the parking structure entrance, saw Malcolm's face, asked no questions. They walked in together. The side door of courtroom 4A opened at 9:17 a.m. Marcus Webb entered first, followed by Malcolm Reed. Malcolm was wearing the same jacket, carrying the same notebook. His shoes were still dark at the toes. He had not changed a single thing about his appearance. The absolute refusal to apologize through his clothing, his posture, or the speed of his walk was something the press row registered before anyone said a word. 3 reporters looked up simultaneously. All 3 looked toward the wall where Pritchard was standing. Malcolm walked to the prosecution table, set his folder down, took his seat. Judge Carter addressed him by his full title. She said the record should reflect that court had been called at 9 a.m. and the state was not present. She asked whether the state wished to place anything on the record. Malcolm stood. He spoke for approximately 40 seconds. He said the prosecution was ready to proceed. He said the record should reflect that he had arrived at the courthouse at 7:43 a.m., that he had been stopped at the special access corridor, that he had presented valid credentials, offered 3 methods of independent verification, and had been physically removed from the building by a courthouse deputy without any of those methods being used. He said the removal had been recorded. He sat down. The courtroom was very quiet. Clifton Vance rose and attempted to use the moment for his client. He suggested the state's situation raised questions about preparation and capacity. He moved for a brief continuance. Judge Carter denied the motion without explanation. She turned to the courthouse marshal, a man named Theodore Park, who had worked the building for 22 years. She instructed him to preserve all surveillance footage from every corridor and access point adjacent to courtroom 4A from 7 a.m. forward. She told him to collect the names of every person present in the courtroom 4 corridor between 7:30 and 9:15 a.m. She said she wanted his preliminary report in her chambers within 30 minutes. Then her eyes moved to the wall where Pritchard was standing. She held the look for exactly 2 seconds. It was not a long time. In courtroom 4A on that morning, it was enough time for everyone in the press row to understand precisely what it meant. She returned her attention to the bench and called the proceedings to order. In the 3rd row on the left, Darnell Hayes let out a breath he had been holding for 17 minutes. Ronald Fitch Wayne Pritchard's direct supervisor had been reviewing the morning's access logs when the first reporter called at 9:34 a.m. The reporter asked whether a deputy under Fitch's command had removed the state's lead prosecutor from the courthouse earlier that morning. Fitch said Deputy Pritchard had enforced the standard credential verification protocol as required. He said he had full confidence in the deputy's judgment. He said any individual who could not verify credentials on site was subject to the protocol. He said the deputy had acted appropriately and professionally. The statement appeared in 3 news stories within 40 minutes. By 10:30 that morning, the institutional frame was set. This was a protocol dispute, a credential that hadn't been presented in the right form, a miscommunication. In 3 of the 4 initial stories, the courthouse's defense of Pritchard was quoted before Malcolm's account. The phrase access protocol appeared in the headline or the first paragraph of 2 stories. None of the initial reports mentioned the physical contact. None mentioned the phrase bus station. None mentioned that 3 independent verification methods had been offered and refused. The frame was doing its work, and the frame was wrong, and it was spreading. At 10:45 that morning, the Florida Bar Association's Jacksonville chapter president received the first call. A black attorney named Jerome Patterson said he had been stopped by Wayne Pritchard 14 months earlier while entering a hearing room. He had shown his bar card. Pritchard had held it at arm's length and said the print looked off. He had stood there for 9 minutes while Pritchard decided whether he was real. He had filed a complaint. The complaint had been closed. She received a second call 7 minutes later, then a third. She sat at her desk with a legal pad and wrote down 3 names, 3 dates, 3 accounts of the same experience with the same person in the same building. She looked at what she had written. Then she called her assistant and asked for the courthouse's public records contact information. The courthouse marshal's report reached Judge Carter's chambers at 10:28 a.m. Park had flagged the access log himself with a handwritten note on the attached page. See credential challenge frequency. Entries 2021 to present. Judge Carter read the log for 4 minutes without moving. Then she told her law clerk, a young woman named Priya Chandran, to cross-reference the 14 flagged entries against the court's attorney registry by race and ethnicity. Priya brought the cross-reference back in 35 minutes. 12 of the 14 credential challenges initiated by Pritchard over the prior 3 years involved black or Latino attorneys, witnesses, or court-appointed advocates. 8 of those 12 had been delayed more than 5 minutes. 2 had been turned away without entry. 2 had filed formal complaints. Both closed without finding. The 2 non-minority individuals who had been stopped were released within 90 seconds. No white attorney had been denied entry or physically removed during the same period. Judge Carter set the document on her desk. She looked at it for a long moment. Then she told Priya to transmit the access log and the cross-reference to the Florida Department of Law Enforcement with a cover letter noting that the court found probable cause to believe the data documented a pattern of racially motivated credential discrimination. She said the original documents were to be preserved in the court record. She said none of this was to be discussed outside the chambers until the contempt hearing she intended to schedule. What she did not do was inform the courthouse administration in advance. They would find out when everyone else did. At 2:15 that afternoon, a victim advocate named Patricia Osei came to find Malcolm outside the courtroom. She told him that a witness without using the name had approached her during the morning recess. A black county employee scheduled to testify. He had watched Malcolm be removed from the building and then watched him return and take his seat at the prosecution table. He had told her that watching the removal had almost made him leave, not step outside, leave, disappear, not testify at all. He had said if they can do that to the prosecutor right here on the first morning, what are they planning to do to me when I get on that stand? Malcolm stood in the corridor with this information. He thought about what it meant that a man's willingness to tell the truth had been genuinely threatened, not by defendants, not by their lawyers, not by any force the trial was designed to confront, but by a deputy at a door who had decided in 3 seconds what kind of person Malcolm Reed was. He asked Patricia to tell the witness without using his name that the prosecution table would be occupied, that he was not going anywhere. Then he went back to work. By 4 o'clock that afternoon, Malcolm's name and face were on local television across 4 channels. The coverage split almost exactly in half. 2 stations led with a civil rights framing. Black prosecutor removed from courthouse on first morning of major trial. 2 stations led with a process framing. Credential dispute delays corruption case opening. Fitch's statement was quoted in every single story. Malcolm's account of the 3 offered verification methods was quoted in 2. The physical contact and the phrase bus station appeared in 1. That evening, a conservative legal blog published a piece suggesting the removal had been deliberate theater. It claimed Malcolm had arrived without visible credentials specifically to manufacture a civil rights incident that would taint the jury pool. The piece was shared 7,000 times within 2 hours. 2 colleagues called Malcolm that night. Both told him the same thing in different language. The defense team was circulating the theater narrative through political channels. They had reached 2 reporters. They were trying to build a story in which Malcolm was the problem. Malcolm sat at the desk in his hotel room at 11 p.m. with his case files open and his phone beside them. He had been working for 4 hours. He picked up the phone and opened the audio file from the morning. He did not need to listen to it. He had been there. He knew every word. But he played it anyway, at low volume, sitting very still, while the rain came back outside. He heard his own voice, calm and specific, offering the verification methods. He heard Pritchard's voice, flat and final, refusing them. He heard the phrase, "Doesn't show up looking like he came from a bus station." He heard it at regular speed. It was bad. He listened 4 times. Then he set the phone face down on the desk and spent the next 2 hours on his cross-examination of the 3rd witness, which he finally got right on the 4th revision. At 9 p.m., the victim advocate sent him a message. The witness had called to confirm his testimony for the following day. He had said that he spent the afternoon thinking about what he had watched in that courtroom. He said watching Malcolm come back through that door in the same jacket and the same shoes and sit down at the table and keep going. He said it gave him something he had not expected to feel in a courthouse. He was going to testify. Malcolm read the message once, put the phone back face down on the desk, kept working. On the morning of the 2nd day before the jury was brought in, Judge Carter convened a formal pretrial hearing. The courtroom was at capacity in a way it had not been the previous morning. Every press seat was filled. 3 additional journalists stood in the overflow area. 2 of the defense attorneys arrived 8 minutes early, which was unusual for people who typically waited until the last moment, as a display of confidence. Wayne Pritchard sat in the gallery at his supervisor's instruction. Fitch had told him to wear his dress uniform, to be present, to sit quietly, and to look professional. He had said the courthouse administration was behind him. He had said protocol was on their side. Pritchard had put on the dress uniform. He had come. He was sitting near the back of the gallery. The deputy beside him, a man named Garrett, whom he had worked with for 3 years, processed the situation within 2 minutes of Pritchard's arrival and shifted almost imperceptibly toward the end of the bench. Judge Carter entered the courtroom at exactly 8:30 a.m. She did not begin with procedural matters. She opened a folder, set it on the bench, and spoke for 4 minutes and 20 seconds. She said the court had reviewed the security camera footage from the courtroom 4A corridor on the morning of October 14th. She said the court had reviewed the courthouse access log from January 2021 to the present. She said the court had cross-referenced the credential challenge records with available attorney identification data. She said the court found that the credential challenges initiated by Deputy Wayne Pritchard over the prior 3 years were inconsistent with random enforcement. She said the data showed a clear demographic pattern. She said the court found probable cause to believe that the removal of Special Prosecutor Malcolm Reed was not based on a legitimate security concern, but on a visual assumption rooted in race. She said the matter had been transmitted to the Florida Department of Law Enforcement for investigation. She said all of this in the same tone she used to issue every finding. Factual, precise, without inflection. She did not use the word disgrace. She did not use the word unacceptable. She did not need to. In the gallery, Pritchard's fingers were white at the knuckles against his knee. The dress uniform he had put on with the conviction that it was protection now felt like it was made of something thinner than fabric. 2 rows behind him, Ronald Fitch heard the words, "clear demographic pattern," and a sound began in his left ear that was not a real sound, but felt like one. A high sustained note of a situation becoming permanently different from what it had been. Malcolm's co-counsel, Rachel Torres, stood. She introduced into the court record Ronald Fitch's public statement from the previous morning, the one in which Fitch had said Pritchard had acted appropriately, that any individual who could not verify credentials was subject to removal, that the protocol was on their side. She noted that this statement had been made publicly by the courthouse's own Deputy Chief of Court Services before the access log had been reviewed. She noted that Fitch's name was now attached in the permanent public record to an institutional posture that the court's findings had directly contradicted. Fitch stood, walked out of the courtroom. 2 journalists followed him into the corridor. He said nothing. He went to his office, closed the door, called the courthouse administrator. In the 3rd row on the left, Darnell Hayes watched all of it. He had arrived at 8:15 a.m. He had sat in the same seat as the day before. He had breathed and told himself quietly that he was going to do this, watching the judge read the findings, watching Fitch leave the room, watching Malcolm sit at that table with the worn notebook open in front of him. For the first time in 2 years of fear, Darnell felt the specific sensation of something tilting the right way. The Florida Bar Association's formal letter arrived at the courthouse administration at 11 a.m. It requested under the Florida Public Records Act Deputy Pritchard's complete disciplinary history, all filed complaints and their dispositions, and all formal credential challenge records. It stated that the Bar Association had received credible accounts from 3 attorneys regarding credential discrimination in the courthouse and was undertaking a formal review. The letter was not aggressive, it did not threaten, it did not need to. A formal public records request from the State Bar Association means the information is coming out regardless. The only question is whether the institution cooperates or resists, and what the resistance looks like. The Florida Department of Law Enforcement Intake Division had already opened a preliminary inquiry file that morning bearing Wayne Pritchard's name, his badge number, and the case classification of civil rights color of law. It was not yet a full investigation, but a file opened with your name on it in a state law enforcement database is also not nothing. It is the beginning of a permanent record that will follow every subsequent event. 3 of the 4 attorneys who had contacted the Bar Association submitted signed statements by 1 p.m. A 4th statement described a different deputy in similar circumstances. The Courthouse Security Division, which had never faced collective institutional attention, was now the subject of simultaneous inquiries from a federal court, a state law enforcement agency, and the State Bar Association. Fitch was called to the courthouse administrator's office at 2 p.m. He came out 45 minutes later, looking older than he had that morning. The public statement he had issued defending Pritchard was, the administrator told him in careful language, something that should have gone through legal review before publication. The courthouse was preparing a new statement. Fitch's name would not appear in it. His prior statement, however, remained in the court record as Exhibit 3. The institutional wall was not down, but it had visible cracks running from the foundation to the top, and everyone on both sides of it could see them. Inside Courtroom 4, the corruption trial was proceeding with the methodical precision that Malcolm Reed had spent 6 weeks engineering. He delivered his opening statement on the afternoon of the 2nd day. He spoke for 31 minutes. He did not mention Wayne Pritchard's name. He did not describe what had happened to him in the corridor. He did not use his own morning as material. What he did was this. He told the jury that the case before them was about how institutions can function as protection mechanisms for the people inside them while failing the people they were built to serve. He said, corruption of the kind they would hear described did not happen in secret in dark rooms late at night. It happened in ordinary office buildings during business hours in the language of memos and approvals and standard procedure. It survived, he said, because people in positions of authority made consistent decisions about whose questions deserved answers and whose concerns could be dismissed. He said sometimes that happens in contracts, sometimes in police reports, sometimes in the way a door is opened or held shut. He said it simply. He did not linger on it. He moved on to the specifics of the case. But 3 jurors looked at each other in that moment. The press row was completely still, and Clifton Vance, who had spent 23 years reading courtrooms, understood that he was already behind. Darnell Hayes took the stand on the 3rd day. He was wearing his best suit, dark charcoal, bought for his daughter's college graduation 4 years earlier. He had pressed it himself the night before. He sat in the witness chair with the careful posture of a man who knows that how he holds himself in this moment will determine something important. Not just about the trial, about himself. He testified for 2 hours and 40 minutes, and he described in specific and verifiable detail how his supervisor had instructed him to approve payment for equipment deliveries that Darnell had personally confirmed were never made. He described the moment he had questioned the approval and been told his job security depended on his cooperation. He described going home that night and making copies of 47 documents, invoices, approval records, email chains, and storing them at his sister's house in an envelope labeled with his own name. Because if something happened to him, there needed to be a trail someone else could find. He had carried those documents for 2 years before he made the call to the Public Integrity Hotline. On cross-examination, Clifton Vance attacked his motivation, his memory, his character, and his employment history. Vance was very good. He was one of the most effective cross-examiners in the state. Darnell answered every question with the steady precision of a man who had been preparing for this specific conversation for 2 years and documented everything so that his memory would not be the only evidence. The jury watched him, not with the performed attentiveness of people trying to appear engaged, with the particular stillness of people who are hearing something true. When Darnell stepped down from the witness stand, he walked past the prosecution table without stopping. He made no gesture, but for just a fraction of a second, his eyes met Malcolm's. That was enough. On the 4th day, a black county clerk named Sophia Morrow took the stand. Sophia was 46, soft-spoken. She had spent the 3 weeks before her testimony cycling between absolute conviction and paralyzing fear in roughly 4-hour intervals. She testified that she had been instructed to destroy a set of vendor invoices in the county procurement system. She had destroyed them from the official system. She had not destroyed the copies she had printed and taken home folded into a manila envelope and placed in a lockbox under her bed. She had kept those copies for 22 months. She said she had not come forward sooner because she did not believe the system would protect her. She said every time she thought about calling someone official, she imagined being the person in the room who speaks and is not believed. Malcolm asked her during his direct examination what had changed. What had finally made her decide to testify? Sophia looked at him for a moment before she answered. She said she had seen the news coverage from the previous week. She had seen a man in a plain jacket get thrown out of the courthouse by a deputy who decided without asking that he did not belong. And she had watched that same man come back through the door and sit down at the prosecution table and open his notebook and keep going. She said if he could do that, if a person could be told by the building itself that he was not wanted there and walk back in anyway and do the work, then she could do this. The contempt hearing was scheduled for 8 a.m. on the morning of the 6th day before trial proceedings resumed. Every press seat was filled. 2 additional journalists stood in the overflow area. Wayne Pritchard arrived with a union attorney named Gerald Marsh and sat at the respondent's table with the rigidity of a man trying to project confidence through physical stillness. It was not working. Rachel Torres introduced 3 pieces of evidence in sequence. The surveillance camera footage from the courtroom 4A access corridor on the morning of October 14th. The cross-referenced access log analysis. And third, the audio recording from Malcolm Reed's phone. Gerald Marsh objected on foundation grounds, and on the basis that the recording had been made without Pritchard's knowledge. Judge Carter overruled both objections in 15 words. The recording was authentic, time-stamped, cloud-verified, made in a public space by a party to the conversation. It was admitted. The recording played through the courtroom speaker system at a volume that ensured every person present heard every word at full clarity. They heard Malcolm's voice measured and specific, stating his role and requesting entry. They heard Pritchard's voice asking which defendant he was related to. They heard Malcolm correct the assumption and offer credentials. They heard Pritchard refuse to verify them. They heard Malcolm with patient precision enumerate 3 independent methods of verification. They heard Pritchard refuse all 3. They heard the moment of physical contact. They heard Malcolm's warning not to touch counsel. And then they heard Wayne Pritchard's voice, flat and certain as a man reading a fact from a page. Counsel doesn't show up looking like he came from a bus station. They heard the instruction to the second deputy. Air quotes around the words, real credentials. The recording ran for 8 minutes and 44 seconds. When it ended, the courtroom held the particular silence that follows something undeniable. Not shocked silence. Deliberate silence. The kind in which people are processing what it means that they just heard what they heard. Gerald Marsh argued that security work required rapid assessment. He said the tone of the interaction, while regrettable, reflected the pressure of maintaining security for a high-profile trial. Judge Carter asked him to identify the specific point in the recording where Pritchard had made any attempt to verify Malcolm's credentials. Marsh looked at his notes. He began to mention the letter in the plastic sleeve. Judge Carter asked him to identify the timestamp at which Pritchard had read beyond the heading of the appointment letter. Marsh could not identify it, because it was not there. In the gallery, Ronald Fitch had left his seat before the recording reached the phrase, bus station. He was in the corridor outside. 2 journalists were with him. He was staring at the wall with the expression of a man performing a calculation he had already lost. At the respondent's table, Pritchard's hands were flat in front of him, and they were not entirely steady. The dress uniform he had put on that morning, with the conviction that it was protection, had become, over the course of the recording, something that no longer felt like protection. It felt like a document of what he had done while wearing it. Judge Carter issued her formal findings. She spoke for 11 minutes. She found that Deputy Wayne Pritchard had removed Special Prosecutor Malcolm Reed from the courthouse without basis in any legitimate security concern. She found that Pritchard had refused 3 offered methods of credential verification and had instead made an assessment that the recorded evidence, the access log, and the 3-year documented pattern all indicated was rooted in racial assumption. She found that the removal had delayed a state prosecution, that it had disrupted trial preparation, and that it had created a demonstrable chilling effect on a scheduled trial witness whose testimony was central to a public integrity case. She found that the behavior was consistent with a pattern documented across 3 years and 14 incidents. She found that Ronald Fitch's public statement defending the removal reflected an institutional posture that the evidence did not support. She referred the matter to the Florida Department of Law Enforcement, the Florida Bar Association, and the Florida Commission on Ethics. Then she turned to the courthouse marshal and, in the same even tone, instructed him to relieve Deputy Pritchard of courthouse duty immediately. Not suspended. Relieved. 2 deputies escorted Pritchard to the security office to collect his personal belongings. The walk was approximately 90 feet. It took them through the main corridor, past the courtroom 4A access perimeter where the morning had begun 6 days earlier. 3 journalists walked the same corridor at a parallel distance. Pritchard did not look at the access perimeter as he passed it. He looked straight ahead. His belongings took 4 minutes to collect. He walked out of the courthouse through the employee entrance. Inside Courtroom 4, Malcolm received the news through a note from Rachel Torres during a brief recess. He read it, folded it, placed it in the inside pocket of his jacket, returned to his preparation for the afternoon's cross-examination. He opened the worn notebook. He picked up his pen. He kept working. The corruption trial continued for 11 more days. The evidence was methodical and, as it accumulated, overwhelming. Inflated overtime submissions backed by pre-signed supervisor approvals. Vendor invoices from companies that did not exist at the addresses listed, 2 of which turned out to be vacant lots. Email chains in which county officials discussed in language that was careful in the way that language becomes careful. When people know what they are doing is wrong, but believe they will never be caught the details of payment arrangements with political donors. On the 7th day, 3 of the remaining defendants entered plea negotiations. By the 9th day, 2 had formal agreements. Each agreement required cooperation. Each cooperation produced new details that added another layer to the picture of how the network had operated and how long it had been protected. Sophia Morrow's copied invoices were introduced as Exhibit 47. The jury had both documents in front of them. The originals recovered from a backup server by forensic accountants, and the copies that Sophia had carried home in a manila envelope and kept in a lockbox under her bed for 22 months. What the jury saw was a woman who had not trusted the official record to protect the truth, so she had protected it herself. What the jury felt watching the 2 exhibits side by side was the specific emotion produced when ordinary people are proven right about how little the official record can sometimes be trusted. Darnell Hayes's testimony held through aggressive cross-examination. Vance spent 4 hours over 2 sessions attempting to establish that Darnell's motive was personal grievance rather than civic duty. He brought up a performance review from 6 years earlier. He implied, without quite stating it, that Darnell was a disgruntled employee who had dressed up a grudge as whistleblowing. Darnell answered every question in sequence. When Vance asked whether he had a personal problem with his supervisor, Darnell said yes. He said the problem was that his supervisor had asked him to commit fraud. He said he had documented every time he raised the concern through official channels, starting with a memo to his department head dated 26 months prior. He said he had not expected anyone to listen. He said he had documented anyway because the documentation was the only version of events that could not be rewritten. Vance had no further questions on that point. The jury deliberated for 9 hours and 12 minutes. They returned to the courtroom at 4:47 in the afternoon. Guilty on all primary counts against Gerald Harmon. 11 counts of public corruption. 3 counts of fraud. 2 counts of obstruction. Guilty on all charges against 2 co-defendants. 3 additional defendants had accepted plea arrangements before deliberations began. The network. 8 years of protected arrangements. Inflated payments. Intimidated employees. The political relationships that had created the insulating layer around all of it. Dismantled. In the permanent public record of a federal court. Harmon sat at the defense table with his hands very still in front of him while the verdict was read. In the gallery, people who had worked for the county and had known for years that something was wrong were sitting with the particular quality of attention that belongs to people watching something they waited a long time to see. Malcolm stood at the prosecution table while the verdicts were read and wrote each one in his notebook. Not because he needed the record. The court reporter was there for that. But because it was his habit. Write the things that matter down. Do not rely on the official account to be the only account. The Florida Department of Law Enforcement investigation took 4 months. Their findings confirmed everything the access log had suggested. A documented pattern of racially disparate credential challenges. A 3-year period in which 12 of 14 formal stops involved Black or Latino individuals. 2 instances in which persons with valid credentials had been denied entry entirely. Wayne Pritchard was terminated, not suspended, not placed on administrative leave, terminated. His employment with the Jacksonville-Duval County Courthouse ended on the date the findings were transmitted to the courthouse administrator. He had been employed there for 11 years and 4 months. The full pension vesting threshold required 12 years of service. He was 4 months and 16 days short of it. He received nothing. He appealed the termination through the courthouse employee union. A 3-person administrative panel reviewed the surveillance footage, the audio recording, the access log, and the investigative report. The appeal was denied unanimously. Ronald Fitch retired 6 weeks after the findings were released, 2 years earlier than he had planned. He issued no public statement. His prior statement defending Pritchard remained in the court record as Exhibit 3 attached to a federal civil rights proceeding. His name was attached to the institutional failure in every legal review, every bar association analysis, and every subsequent discussion of the case. The courthouse implemented mandatory credential verification protocols, requiring any disputed attorney credential to be reviewed by a supervisor within 3 minutes, and requiring supervisor sign-off before any removal. Every security deputy underwent mandatory retraining. 3 attorneys who had submitted signed statements received formal written apologies from the courthouse administrator, the first apologies for credential discrimination in the history of the courthouse. Wayne Pritchard found work as a private security guard at a commercial office complex 2 miles from the courthouse. It was a different kind of job. He stood at an entry kiosk near the parking structure and checked employee badges against a roster system. The system made the decisions. He executed them. He did not assess. He did not evaluate. He did not decide who belonged. On some mornings, attorneys he recognized from the courthouse walked past his kiosk on their way to their offices. They did not slow down. They did not look at him. He had stopped expecting them to. Malcolm Reed declined 3 media requests for personal interviews in the 6 weeks following the verdict. He declined a national podcast appearance. He declined a cable news segment. He told his assistant to explain that the verdict belonged to the witnesses. He accepted one invitation, a panel discussion at the Florida Bar Association's annual conference on courthouse access and racial assumptions in legal spaces. He spoke for 22 minutes and left 8 minutes for questions. His remarks did not mention his own experience from October 14th until the 20th minute, and even then he mentioned it in one sentence and moved immediately to what it had revealed about the conditions that made it possible. He did not describe it as exceptional. He described it as documented. At the sentencing hearing for Gerald Harmon held 4 months after the verdict, the State Attorney General's office formally recognized Darnell Hayes and Sophia Morrow for their cooperation and their courage. Sophia received a small, framed certificate. She held it with both hands and looked at it for a long moment. Across the room, Darnell caught Malcolm's eyes. He nodded once. Malcolm nodded back. No speeches, no ceremony between them. They did not need it. At the Bar Association forum, a young attorney in the audience asked Malcolm what advice he would give to someone who experienced something like what he had experienced. She asked it carefully. The way someone asks a question they have been carrying for a while. Malcolm said document everything always because the official record is not always your friend. He said, do not modify yourself to fit the assumptions of people who have already decided what you are. He said the work is what matters, and doing the work is the answer to most things. Then he said one more thing. He said that the morning it happened, standing in the waiting area of that courthouse in a damp jacket with his notebook under his arm, the thing that kept him level, the thing that kept his voice even and his hands still, and his mind on what actually mattered. It was not that he knew justice would come eventually. He could not have known that with certainty. What he knew was that he was right, that the record would show he was right, and that the only thing he could control was whether he acted in a way that the record would confirm. He said truth does not need to perform. It needs to be documented. And then it needs to walk through the door, whatever that door looks like. Courtroom 4A. Sentencing morning for Gerald Harmon, October. The rain had come again overnight, the way it comes in Florida in the fall. Sudden and complete. and then gone before the workday begins, leaving the pavement dark and the air thick with the smell of wet concrete and something almost like relief. Malcolm Reed arrived at the courthouse at 7:51 a.m. Navy jacket, worn notebook, slim folder, no entourage, no announcement. At the access perimeter for the courtroom 4A corridor, there was a new deputy, 27 years old, 8 months with the courthouse. He had received training that included a case study drawn from the events of the previous October. He did not know who was walking toward him. He checked the morning's docket on the tablet mounted at the perimeter station. He read the name. He looked up. "Good morning, counselor." He stepped aside and held the access point open. Malcolm Reed walked through without breaking stride. He walked down the corridor and through the doors of courtroom 4A. He set the worn notebook down on the prosecution table. He set the slim folder beside it. He looked toward the gallery where ordinary people were finding their seats. County employees and journalists and family members and citizens who had come because something important was going to be resolved today. He opened the notebook to the page he needed. He picked up his pen. The courtroom filled around him and he was ready. Outside on Congress Street, the wet pavement was already beginning to dry. If this story stayed with you, subscribe to our channel. Stories like this one exist because people refuse to let the record be erased. We're here to make sure it stays that way.